Finally, boards of education can go into executive session to discuss a record that is exempt from public inspection under the Open Records Act if there are no reasonable means by which the board can consider the record without disclosing the part of it that's exempt from disclosure. The one place this is most frequently used has to do with student records. There are actually provisions in Title 20 itself that require you to go into executive session to discuss appeals from student discipline tribunals. But even if that provision wasn't in Title 20, this section would require you to go into executive session because student records, tribunal transcripts, student records that are part of the discipline record, are protected by federal law and are thus exempt from disclosure under the Open Records Act. So you'd have to go into executive session to review that portion of the record. There may be other exceptions because this is a change to the reasons to go into executive session. An example that comes up occasionally would be a situation where the board is actually considering two bid proposals and has not made a final decision. So bids that are private are not subject to the Open Records Act until a final decision has been made by the board. So if the board is meeting and reviewing the bids themselves before they're made public, then it's arguable that they could do that in executive session. Back to student issues for just a moment. Besides just student discipline, did not want to leave the impression that it was only student discipline. Occasionally the superintendent may need to discuss a specific student matter. Many boards allow students to seek to waive attendance zone requirements. Sometimes the superintendent may need to discuss a particular special education matter where perhaps a lot of money is going to have to be spent by the school district to serve a particular child. Anytime an individual student is being discussed, and thus those student records would be part of the discussion, this provision of the Open Meetings Act allows and requires an executive session by the board.